This is basically a webinar dealing with questions and answers related to Canadian immigration law. It's meant to bridge a gap between the ocean of information on the internet, sometimes not mediated very well on the IRCC website, and also interspersed with the Canada Border Service Agency website and the Service Canada website, which has some interconnections to immigration processes, and to a lesser extent, the CRA website, the Canada Revenue Agency website. In addition, there's, as you may know, if you have an immigration question, you may have researched it on various AI platforms, and those in turn purport to have a synthesis of information gathered from various sources, including perhaps lawyers' websites. I'm told that by some clients that they found some reference to my website or a blog of mine by simply searching up, for example, humanitarian and compassionate on AI, or searching up spousal sponsorship on AI. So today, this is meant to be general guidance, not substantive advice, because we need more detailed background for a lot of these questions. For substantive advice, every lawyer will tell you you would want to book a consultation and get more context by that venue for this. But nevertheless, there are rumors that pop up. There's more and more frequently, there's no context announcements by the Minister of Immigration, which indeed leaves even lawyers who are meant to search and be aware of this, leaving lawyers in the dark sometimes. And sometimes that ends up being discussed here, and there's a bit of speculation for that. And I will just go to one of the questions that I see here, which is, what is a complicated spousal sponsorship application? Because your office said that the fee for a complicated spousal sponsorship is greater than a fee for a standard sponsorship. So I hope we answered that question to the person by text or email, but in the event we didn't, then we look at a spousal sponsorship in two ways. One is, what is the factual matrix, which is simply a fancy way of saying, what's the background of the individuals? The background of the individuals may pertain to the nature of the relationship. So, for example, a less complex spousal sponsorship will be one where it's a couple who's never been married, perhaps they're under 35, similar in age, similar in their environment or upbringing or culture. And they had a regular courtship, which I would somewhat arbitrarily define as at least knowing each other for like 8 to 12 months before a proposal emerged and marriage. And there would be a reception where there would be close family, friends, etc. And depending on their economic circumstances, there may be a honeymoon or something more simple, like simply going to the more kind of posh parts of town, especially if one spouse is not from that town where the other spouse may hail from, for example. And then that would be buttressed by evidence of the communication, because at a certain stage, there would be chats, either through, depending on where the spouses, where they were located before they were married. They might be WhatsApp in the event that there's a long distance relationship, etc. So by contrast, if we think of what is a more complex sponsorship, you can kind of infer based on that the circumstances would be sort of like the opposite. So perhaps there would be a significant age gap of, let's say, more than 8 or 9 years. Maybe one of the spouses was divorced, or maybe one of the parties had some kind of criminal interaction or an immigration interaction in another country, the nature of that interaction with the immigration authorities in another country may have led to the conclusion that they were not compliant with the immigration laws of that country. And as a consequence, there may be some concern about whether the marriage is genuine based on simple lack of compliance. I'm word with some context. And from that vantage point, that's where you need to get capable legal representation. So the intake process with a lawyer was to glean and ascertain these relevant facts before giving some advice about the level of complexity which may affect the things like the lawyer's fee and the processing time for the spousal application or common law application, and may similarly trigger a need for an interview with the immigration officials, which again is a sign that you want to apprise or be apprised of when you're going through a spousal sponsorship about what additional complexities may take place, such as whether or not there is a likelihood of an interview or not. So that's the one question. I'm going to go back to the chat. So this one, okay, so this relates to asylum. So it is, how can people with pending asylum in the USA move to Canada? So the answer to this is a little bit in flux. I mean, there is what's called the Safe Third Country Agreement, which means that getting to Canada is difficult if you've already landed in the United States, because the very short form version of that agreement says that if you land in one of Canada or the United States, you're expected to make a claim there first. The rationale is that if you have a sincere, genuine, subjective fear of staying in your country, then logically you'd want to make a refugee claim where you first land to express this fear that cannot be cured by simply seeking redress by the police or other government authorities in your country. That being said, the Safe Third Country provisions include exceptions where if you have a family member in Canada, and I believe it's at least nuclear family, brother, sister, may include aunt or uncle. And if there's proof of that, then despite the fact that you were in the United States, you could approach the Canada-US border and say, I have a relative in Canada. So despite the fact that I'm in the United States, I want to make the claim in Canada. Again, from the rationale of why they have this exception, it might be that maybe the relative in Canada also has a refugee claim, or maybe they're just simply well established. And then it's in a normal family situation, you want that family support if you're fleeing persecution. So this is not the end of the analysis, however, because in some cases, and I'm going a little bit by memory here, if you have had a refugee decision in the United States decided upon, then I'm quite certain that you're simply ineligible to make a refugee claim in Canada. I would have to double check that. And so I'd suggest a substantive consultation for that. But based on a lot of this has been in flux, because as the anti-immigrant sentiment ramped up after 2024 or 2023 in Canada, owing to the proliferation of many study permit holders and the sort of economic downturn, there were more and more changes to the ability for people from the United States to enter Canada as refugees. And indeed, when we have stakeholder meetings with the Canada Border Service Agency I went to a meeting in Niagara Falls with the CBSA officials in June of 2025, and they were saying that they were budgeted to ramp up an expectation that there would be asylum claims from the United States. So their shield in this respect is the alterations to the uh, this safe third country agreement, which included restrictions on who could come to the border. I mean, you can no longer simply get smuggled over the border, which was sort of the norm until I believe 2024, and then simply make a claim. So you have to declare yourself at the port of entry. So regretfully, I can't say with confidence if a pending refugee claim in the United States would automatically bar you from making a claim in Canada. I'd have to check the safe third country provisions, but I'm reasonably certain that if a claim is decided, you simply cannot make a claim. But you could make what's called a pre-removal risk assessment at the Canada-U.S. border, which is a kind of miniature refugee claim where there is no right to an interview, as there is in the Immigration Refugee Board inland refugee process. It's discretionary, but a lot of the subject matter is the same, whether there is a fear that you have that cannot be addressed by the existing authorities in your country, such as the police. And the country conditions are such that you still have a subjective fear. Again, this will be in flux again because putting it politely, the immigration policies in the United States are not inspiring confidence if they are deputizing police in certain states with a certain political persuasion, at least from a superficial point of view, to intimidate people in those states which have a certain political persuasion. Wreaking havoc with the rule of law in the United States means that those observations will be funneled into any Canadian federal court challenge to whether or not the Safe Third Country Agreement actually is protecting refugee claimants who make a claim in the United States. Given the jeopardy of the rule of law in the United States, given the history that there has been assertions at the federal court that the United States is incapable of protecting refugee claimants, then this issue is still a live one. So I hope I provided some context to that. I think a sort of different, we'll go to the chat. Okay, so there's a different question here. So it says, I have a 3-year diploma and 10 years experience in the engineering field. Can I apply through express entry? So I think this question relates somewhat previously to the previous one, where this person might be a refugee claimant in the United States. And then the question is whether or not if I provide some context to an express entry profile, the question is whether or not my education and work experience, some of which may have been performed in the United States, where I may or may not have had legal status, can that still be the basis for an express entry profile? So I would say, like actually many lawyers say, yes, but. So the short answer is yes, but if you were working in the United States, to have that work experience counted in your express entry profile, you would have to ensure that you have all of the hallmarks of what could be construed as genuine work experience. So a lot of this is sort of intuitive, which is evidence of being paid, evidence of a job reference letter from somebody who is an authority to vouch for the work duties you have performed. That work reference letter should be substantive in describing the duties, substantive enough so that the work reference duties can be cross-referenced to the National Occupational Classification, so that the officer tasked with reviewing the potential invitation to apply can say, oh yes, this set of duties in this work reference letter does correspond with a certain NOC code, hopefully at the right skill level. And further, that the work was maybe having third-party corroboration. In some cases, this may mean that there would be what I believe in the United States are called W-2s, which is simply some form of paying tax for this. The the case gets a bit more complex if the person submitting the express entry profile based on work experience performed while not possessing valid work permit status in the United States. It might become a little bit less clear to the Canadian officer about whether or not the work performed was actually performed. The concern would not necessarily be simply the lack of work visa status in the United States. That may not be the determining factor. However, in some cases where the work is being done illegally, there may be less willingness on the part of the employer to write a substantive letter for the purpose of presenting to the Canadian authorities. Some employers are reticent about that because they may or may not be in compliance with U.S. working laws, and they may feel less comfortable about that. But on the other hand, if you have an employer who is able and willing to write a substantive letter, despite the fact that you do not have valid legal work status in the United States, then this arguably might still be a good basis for an express entry profile. It reminds me of a meeting at a webinar we had when there was a Canadian visa office in Buffalo, New York. On a panel, the Canadian manager of the Canadian office in Buffalo, New York in those days said, "We're not in the business of enforcing U.S. immigration law." But he was very careful to say that, I mean, obviously other laws, like other criminal laws, I mean, those are obviously of great concern to the officer. So let me switch if there's a, I'll go to the chat again here. So, well, this sort of looks like a follow-up to the same question I just answered. So the person indicated that they do have work authorization, which is good, and there's contracts with employers. And one of them being, I think, with a Canadian firm, it says, okay, so that sounds like perhaps remote work. So that would inspire some confidence in me saying, yeah, I think you could have the fundamentals for an express entry profile in that situation. Then it becomes a bit more like an ordinary one where we don't have to contextualize the work experience and advocate quite as aggressively in the absence of substantive evidence from employers and other third parties like the tax departments in the United States. So there's chat. Oh, no, there's a question here. Okay, so this pertains to, I think, investment. Okay, so what are the net worth and the investment requirements in different provinces and cities? So this, if we try to break this down, there's the federal regime, which relates to, at least officially, when you look at the structure of the federal regime for this, the only one that is subsisting is the C-11. I mean, there's a startup visa, but I think that was closed and it's being revised just because there's too many concerns about like non-genuine investments. So if we think about the federal, there's the ability to legally work in a business where you have, I believe, a 49% share that comes under C-11. Then there's the provincial. The provincial authorities in most of the provinces and territories have in place a way to scrutinize would-be investors. And for those, they have a term, a set of sort of multi-stage assessment. So when I think of, for example, I think British Columbia, the scrutiny relates to business plan and amount of money. So the difference, one substantive difference between the federal C-11 regime and the provincial authorities, entrepreneur streams, is that there is a substantive advertised amount in the provincial entrepreneur or would-be entrepreneur categories. And so it tends to vary based on whether the business would be deployed in a larger city or in a smaller city, where from a policy perspective, the the provincial authorities, they want to they want to encourage people to sustain these smaller towns, keeping them viable just from a sort of economic and demographic and environmental point of view. So the range, there's so many. Like if we think of one extreme in British, I'll go to British Columbia again because I think I can recall that one. So like there's like an entrepreneur base stream with the net worth is 600,000, and then I believe the investment has to be 200,000. Then they have the regional stream in British Columbia where I believe it's $75,000 outside of large cities like Vancouver, and the net worth is half, 300,000. Then I believe if we look at a couple of other ones, maybe I could call it up here. Saskatchewan, the Flat Province, geographically speaking, they want, I believe it's 500,000. And then in the amount to invest, I believe it's 300,000 if it's in the two large cities, which are, obviously Regina, the capital, and I believe the other one is not Lethbridge, but Saskatoon. And then if it's outside of those cities, then the investment has to be 200,000 instead of 300,000. So there's a slight reduction. The Manitoba, maybe I could call it up here. I don't want to, I'm going by memory, right, to some extent, but I believe it's 500,000 net worth in Manitoba, and then 250,000 in the larger cities in Manitoba. I was thinking of Alberta. I just can't think of that one. And then there is the smaller provinces in the Maritimes, and I know for that they still want people with a good net worth. I know for Nova Scotia, if it's in the large city area, like the net worth has to be 600,000 Canadian dollars and investing at least 150,000. So I mean that might be the fact that in Nova Scotia the 150,000 amount is a lot less for that sort of capital region. I think it's a reflection of the fact that the economic market, even in the capital region, is a lot smaller. So they don't have to necessarily demand, let's say, 200,000 or 300,000 as they demand in the other provinces to be located in a urban area in Nova Scotia. So that gives at least a sense of the range. But by that was all the provincial aspects. But if we look at the federal with C11, it used to be a relatively safe pathway for permanent residency, but because they've made many changes in the past 2 or 3 years, they're taking a more strict interpretation, it seems, where they don't really make it clear anymore that there's a definite pathway for permanent residency. They're taking a very strict reading of C11, where it's, when you look at it on the face of that program, it's really you're a high value employee working for this, and you may have managerial tasks. But when you look at a C11 sort of in its own context, without the historical pathways that accrued from there, it's really making an executive level job and making sure you have the possibility of transferring that ownership to somebody else. That's the strict reading that seems to be how they're carrying it out nowadays. The reason or the basis for that change was when they got rid of the extra points under express entry in March 2025, where if you had an executive job working in Canada, you'd get 200 extra points. So that would compensate for the presumed age difference for somebody who is as an executive doing an executive level job. So then, in other words, C11 used to be a safe pathway through express entry because you had the extra points. You don't now, as of at least now, March 2026. So as a consequence, you're kind of stuck if you got the C11 work permit for the short-term future. I mean, they've told us the points will return, but they have not returned yet. It's been like a year. So for would-be business persons, the structure that is attached to the provincial entrepreneur programs, where you present a business plan, where they scrutinize it, and then they give you like a work permit for a duration of between 6 months to 19 months, and they review the progress of your business while you worked on that closed work permit in that company, and then they issue a certificate of nomination and then get PR is a lot more safer from a business point of view. So that's sort of the other one. So I think there's a comment, okay, a more specific comment with Kelowna. Yeah, I believe Kelowna, if I call up, I'm thinking if I have a previous business case in British Columbia in the past 2 years with this. So I'm assuming, I can't say with certainty about which threshold that is. Is it the 600,000 net worth, 200,000 investment, versus 300,000 Canadian versus and 100,000? I believe Kelowna. Let me see here. Let me see. For Kelowna, because I'm from Ontario, so I don't know the geography of British Columbia that well for this. So I can maybe look it up later. Maybe if there's a lull in the questions, then I can do it. But but in the meantime, let me see. Going back to the this. I'll look at the chats. Okay, so the business one I'll come back to. I'm just going to pivot to the question that was emailed before the webinar, and so that one relates to I have lost my, or is it? No, it's a different question. Okay, I was on a visitor visa status and it expired 40 days ago, and what will happen to my status? Okay, that's a bit open-ended, but at least I can sort of go over the general structure of that. So the person had visitor status in in Canada, and they wanted to know what is their status now. So obviously, with the expiration of status, that would be evident to you. For example, if you came to the airport, you would normally have a stamp issued by the Canada Border Service Agency. The presumption is that you have 6 months status. In some cases, they could curtail that amount of status at the port of entry, such as the airport, and they could handwrite in a lesser amount of status, in which case then you would have to renew the status before that time. In this person's question, they said a certain amount of time has elapsed since they've lost that visitor record status. So then, in that situation, what is their option? So to be complete, they could simply leave Canada. There's a small risk that this could be an issue if they try to re-enter Canada with a new visitor visa, because the Canada Border Service Agency, they communicate with the airlines when you leave Canada. So they might detect the fact that you left Canada after your status expired. That could be explained if there were circumstances beyond your control. On the other hand, since they have been their status rather is has expired less than 90 days from the time, then they could employ what's called restoration, where they could restore their status back to a visitor, and then they could stay longer. However, in that context, when you restore your status, you have to have a new purpose presented to the immigration authorities, a new purpose that has to be consistent with the status of visitor. So obviously, you can't be working. You could be doing a short-term course, less than 6 months duration. You could be doing typical Canadian sightseeing things because Canada is a large country. To give some credibility to that, you may want to have some specificity about that. That could be an itinerary, maybe a hotel booking, maybe airplane or train tickets going across the country to buttress that, to show that you do have a genuine temporary purpose to continue. And it doesn't hurt to provide some context as to why you did not renew it further or earlier than the time when you should have before it expired. So in that case, the officer could reasonably restore your status. You have to be aware, however, that in some cases we've seen, especially now, because there is a more enforcement-minded environment in Canada, that the Canada Border Service Agency, they could detect your lack of status, and they could call you in, let's say, even at the 40-day mark like this, and write you up, as we say in the legal parlance, under Section 44 of the Immigration Refugee Protection Act, or a report under the auspices of failing to possess valid status. And if they don't see that there is some effort to restore your status, they could issue you a 1-year exclusion order, barring you from Canada for 1 year from the date you depart from Canada. And that would simply not look good in the grand scheme of things if you want to re-enter Canada, because then they would see this in the computer. I see there's perhaps a related follow-up question to what I just said, sort of cross-referencing the question from email. So that's so it looks like one individual is saying, if I understand, in the middle of June, the 6 months would be over in 2026. And then can I apply for an extension? So you could apply for an extension. The norm, however, is that typically you want to have some specificity about the extension. The safe route is to ask for a 6-month extension with some evidence, or at least a narrative of what you're going to be doing. And that way, the officer would be more inclined to grant the extension. We see extreme cases which come to mind just because we deal with more complex cases where people have like a parent visiting Canada, and maybe they were here for a year or two, maybe because of COVID. Now, COVID is long behind us. And then they're in a situation where they have to extend their visitor status after residing here for perhaps 2.5 years. It gets very complicated because by that measure, an officer could reasonably presume that in this case, the parent does not have a strong tie to their home country. If they've not been back for 2.5 years, where are they going to go? So that it becomes much more complicated to prove to an officer that there is a genuine intention. This is in contradistinction for, let's say, super visa holders, which are basically parents of Canadian permanent residents or Canadian citizens who can stay for like 5 years inside of Canada, which is a niche policy tied to the inability or unwillingness of the Canadian authorities to allow permanent resident sponsorships of parents. So that's a very niche situation. But you do not get that level of flexibility in terms of being able to stay in Canada if you're not like a parent of a Canadian permanent resident or citizen for this. And I think, let's see, I'll go to the chat. Let's see. So this might be related to the visitor visa discussion. So this might be related to potential evidence to submit for a visitor visa extension. So it mentions rental contract paid till the end of this year, I presume 2026. And there's some specificity, rather saying I'm researching a startup business. I think that makes sense because you're not working. You're doing an exploratory visit. It's vaguely analogous to like the business visitor visas where people are saying, I'm not entering the labor market in Canada. I'm just saying that we have a service which we deploy outside of Canada. We're thinking about deploying it inside of Canada. So they're not really jeopardizing jobs for Canadians, which is front and center of what the Canadian government's mandate is these days. So let me pivot to I don't see anything in the chat here. Excuse me. So pivot to the questions here. Okay, so travel document. So this one is, let me go back here. Okay, so my permanent resident card is going to expire March 30th, 2026. I have not been in Canada for 2 years. Can I maintain my permanent resident card? Okay, so this is, I will try to walk through this. I guess there wasn't enough context. So this is an important discussion because people who are outside of Canada, unless they are from a visitor visa exempt country, then they have Canadian permanent resident card status, then the norm is that they cannot board a plane without a permanent resident card. And so in this case, the person has, their card is going to expire March, well, in a few days. So the knee-jerk course of action is simply to get on the plane if they don't have work obligations in their existing country or family obligations. Keep in mind, however, that in this scenario, it could be extremely dangerous because if you hop on a plane saying, oh, I've got my PR card and it's going to expire, so you can't catch me, you end up at the port of entry, and then the Canada Border Service Agency officer says, wait a second, you landed 5 years ago, and then they do the math, and they said, in this 5-year period, based on the amount of days you've accumulated, you do not have 730 days. And if we look at this scenario, the officer may calculate there's only 4 or 5 days left on your permanent resident card, and you will not accumulate the minimum 730 days. So they can write you up right away for failing to maintain the obligation of a permanent resident card holder, which is namely to maintain 730 days in a 5-year period, subject to exceptions like accompanying a Canadian citizen spouse or working on a Canadian business abroad. So you want to get substantive advice, number one, to determine, will you have the amount of days, assuming you want to come back on this existing card? And if you don't, then we have to consider the other option, which is a PRTD, a permanent resident travel document. So that is when a permanent resident card has expired. And then you apply for that at a Canadian visa office abroad. And for that, the officer abroad is tasked with determining why your permanent resident card expired. And do you also have the minimum 730 days out of the 5-year period? And or do you have the exception, which can relieve you of that requirement for having 730 days, namely you're an employee of a Canadian business dispatched by the Canadian business? Or are you accompanying a Canadian citizen spouse? In those days, under those circumstances, those days, doing those endeavors would relieve you of the minimum 730 days. But an officer, I mean, historically speaking, we know officers who are dealing with PRTDs, permanent resident travel documents. They're highly skeptical of the reasons because they come across, from what I understand, they come across situations where people simply landed as permanent residents in Canada and went right back to their work because they couldn't find a good job in Canada. I mean, we see this with business people in China or workers who used to get permanent resident while working in the Persian Gulf and returning back there, although that may be changing now, given current world events. And so officers take a very dim view of that. They're saying, well, you got the permanent residency. You simply up and left and returned back to your previous country and worked. So they'd be less inclined to grant the permanent resident travel document and be more inclined to take away your status. It wouldn't be the end of the analysis. The officer taking away your status would trigger a right of appeal at the Immigration Appeal Division of the Immigration and Refugee Board. And if you're outside of Canada, you can appeal within 60 days. And you could plead humanitarian compassionate grounds. I mean, it's preferable if you pleaded those at the Canadian visa office level in the context of the PRTD, where the officer might be more lenient. But if you did not, you could still plead those at the IAD, Immigration Appeal Division. But again, what would be front and center is, would the circumstances that you present show that you made or ascribed a high priority to maintaining the obligation for a permanent resident card, and the obligation being spending 730 days in a 5-year period? And if not, were there sufficient humanitarian compassionate grounds which could lead the decision maker at the IAD to understand that it was beyond your control, such as caring for a sick relative? Or in one instance, I had a client where they had a family law dispute in India, which was taken so seriously by the Indian authorities that they seized his passport. So he had proof of that. And they were not going to let him leave India because I think there was a child involved, and there was some concern about whether there was the best interest of a child, which had to be factored in, and they wanted to make sure that was squared away before they returned the passport for that person in his family law dispute in India. So you want to make sure that, again, you get legal advice about those kinds of things before jumping on a plane with a PR card that is technically valid in hand, and then end up getting what you feel like is an ambush by the Canada Border Service Agency officer at the airport, who takes away your status, necessitating you to either enter Canada as a visitor to give up your status, or to appeal within 30 days, in that case, if you get that kind of decision at the port of entry for this. So let's see, I want to see, we still have some time, so I want to address any questions in the chat as well here. Let me just go to that 1 second here. And okay, so this one relates to, I was deported from Canada and I tried to enter Canada as a visitor. I'm a United States citizen, and I was told I could not enter Canada. What are my options? So for this, the person said they were deported. So technically speaking, if you want to re-enter Canada, a deportation means you need the requisite cure for the deportation under the law, which is called an authorization to return to Canada, or an ARC, as we say in the immigration business lingo. So an ARC is characterized by government fee and also an explanation about what were the circumstances surrounding your deportation. They want to know, really, for example, were you resisting deportation? Was the deportation due to some kind of inadvertence where there was a miscommunication? In other words, are you a safe risk for re-entering Canada because there was a clear violation of the immigration laws? So in this circumstance, the ARC would be the venue for which you to explain what were the circumstances surrounding your deportation. That wouldn't be the end of the analysis. You might want to add whether there is an important purpose for re-entering Canada, such as maybe there's an elderly relative who's based in Canada. You want to see that relative. I mean, that could be something important. Or maybe you're a person who's got a job offer in Canada, because U.S. citizens under NAFTA or CUSMA, as the case may be, however you characterize it, they could, under the worker list for that agreement, they could have a job offer. And in those situations, there'd be a very important purpose, and that could be the reason to allow the officer to use their discretion to grant the authorization to return to Canada, or ARC. That process, I think in theory, could be done at the port of entry, but I don't see it successfully there. If there is, on the other hand, a more pressing reason to enter Canada, and you're at the Canada-US border as a US citizen who was deported, you could plead for what's called a TRP, or temporary resident permit. And that would be the avenue for the Canada Border Service Agency officer at the port of entry, like the border or the airport, to quickly assess what the purpose is. Let's say, I'm recalling a case I had years ago where the person was competing at an equestrian event in Calgary, and they had a minor criminal conviction. They weren't deported, but I mean, the remedy, the short-term remedy for this is the same. It's a temporary resident permit where the officer is tasked to assess the needs of the candidate seeking entry versus the risks to the immigration system of Canada. And based on that calculus, the officer did grant the person who had a criminal record, on the basis that they had a very important purpose, namely competing for an event in Canada, and their criminal interaction or criminal record was relatively minor, and it was in the past. So that'd be the other avenue to enter Canada despite having deportation, or as the case may be in the latter example, having a criminal record. So it's either ARC if you were deported, or if you had a criminal issue, then a TRP, temporary resident permit, for this, to cure a criminal conviction performed or carried out outside of Canada, but still having a purpose to enter Canada that is reasonably compelling to the officer. So I see something in the chat in terms of question, which is, let's see, can I use my previous work contracts from previous employers if I can't get the reference letter from them if applying for express entry? And there's also copies of pay slips and tax filings. So this relates to the arguably the core of an express entry profile, which is the work experience component, because that is the way the Canadian government, through express entry, determines who gets in on the basis of economic needs of the Canadian labor market. So they will scrutinize this very, very carefully. And if you're fortunate enough to have work experience that is relevant, where they, for example, reduce the amount of points required under the express entry draw because of the labor market need, then you want to have credible evidence of that work experience. So, in a situation where there is not like a recent letter from the employer, you could make the case that for example, as cited by this individual, there is work contracts, and if there is pay slips as well and tax filings, that could arguably address the two core pillars of the work experience, which is evidence of the duties performed, which hopefully is in sufficient detail in the work contracts, and evidence that you are in an employer-employee relationship characterized by remuneration, namely you were paid a salary, and pay slips and tax filings would fulfill that other component. We've done these cases in the past, and in some instances where there's a real reluctance, then we have an affidavit sworn by the client, or in some cases, an affidavit sworn by the client, and or an affidavit by maybe a work colleague who did work with them at the time, just to fully square away this issue, because it is so central to the express entry, in this case, FSW, Federal Skilled Worker category, since this person is outside of Canada, that we want to really, really put the officer at ease and put this issue to rest so that it doesn't get refused on a technicality, because the express entry regime, although there's a rationale to it, it's basically an inventory management system. To the end user, it feels like a lottery because the point system fluctuates so rapidly based on labor market needs that you want to really get that express entry profile accurate at the outset, because if you get invited based on the work experience you presented in that express entry profile, you may, and we've seen this in some instances, like the client comes to us after they're invited, and then we have to say that you can't take this invitation because the chance of success is very low, because the work experience presented in your express entry profile isn't borne out by the actual evidence or some other issue. And then we have to say you have to withdraw or not accept this profile, re-input your express entry profile, and hope that the occupation gets selected again, which may or may not occur because this is they have what are called targeted draws under express entry since May 2024. I saw an announcement, I believe, a couple of days ago where they're going to increase points, the sort of beneficial rather points under express entry, depending on the work experience, which is simply another way of having targeted draws. I mean, I only looked at this announcement quickly, but I mean, if you're fortunate enough to have work experience that is going to be in demand in the short to medium term, then it does make sense to have a good, solid express entry profile scrutinized, hopefully by competent counsel. And we're competent counsel here in our office, here at Chaudhary Law Office, if necessary, for this. So I want to pivot back. We still have 4 minutes, so I'm going to go to the question related to this other aspect. So this one relates to medical admissibility. I'm going to characterize it. This is the person who says, I've been invited for permanent residency under express entry, and I have HIV, and I've received a procedural fairness letter expressing the concern that the amount of money that my condition has would exceed the medical threshold. So for this, this is basically potential inadmissibility under the Immigration Refugee Protection Act on the basis of medical conditions. So in a situation like this, because the Canadian healthcare system does have, in some instances, benefits accruing for, in this case, what I would presume are drugs, the Canadian officer has identified that in some instances, people who are on HIV, they need a certain amount of medication, probably for the rest of their life. And then the officer presumably wrote a procedural fairness letter expressing this concern. And this concern would namely be that the amount of cost for the medication would exceed the medical admissibility cost threshold for an individual. That medical admissibility number, a dollar amount, is announced every year, I believe in January, and I believe it's $22,000. So my presumption here is that the medical officer communicated to the Canadian immigration officer about this case and said that the amount of medication this person would need would cost more than 22,000. Don't quote me on the 22,000 because it goes up. And this led to the issuance of a procedural fairness letter. I haven't done these quite a few times in the past. They usually get 90 days or so for a procedural fairness letter related to medical inadmissibility. And the purpose of the PFL, or procedural fairness letter, is to provide you an opportunity to say, no, I do not exceed this $22,000 medical excessive demand threshold. For example, maybe this person has access to medication through a plan outside of Canada, which they can access after they become a permanent resident, or some other solution. Or in some cases, there's humanitarian compassionate grounds, depending on the type of condition and whether there is what is called a mitigation plan. Maybe they do have some ability to have their own financial wherewithal to address this concern about having a financial, being an excessive burden on the basis of financial cost of medical demand in Canada. So for this. And then I'll go to I see something in the chat. So let's just take a little sippy break here. So this question relates to passport expiration. Passport expired while in the United States. Since this person has a pending asylum claim, they cannot seek the services from the home country while in the United States, which is true because you're seeking refuge from the country that's persecuting you. So it's not appropriate to approach the visa authorities of that country. Doesn't make sense. So I understand why you would not do that. So how can I submit my application for express entry if I do not have a valid passport? So this is a fundamental component for any kind of permanent resident application. We see this more often in situations where the refugee claimant actually comes to Canada not under express entry, but under, let's say, an overseas refugee settlement program. And in those instances, the solution is already in that process, namely that in that context, as an overseas refugee who settled under a Canadian refugee program, such agreement holder, then that person has been vetted sometimes by the UNHCR. And that allows the Canadian authorities to land that person by giving them what's called a single journey travel document. That's pretty common in the refugee context. However, in this instance here, this person is not an overseas refugee being settled in Canada. They're a putative express entry applicant. So in this case, in theory, a single journey travel document might work, but the heart of a successful single journey travel document is that your identity was verified. I would take an educated guess and say, in this instance, because the passport was valid when the person made the claim in the United States, then there's an argument to be made that the US government and the US asylum tribunal or authorities, they did verify this person's ID. And maybe, as is the case in the Canadian context, they gave the person a certified copy of their passport in the event that it was seized by the US authorities. So that could be arguably the basis for a person who filed a successful express entry application leading to a successful invitation to apply, leading to a successful e-application for permanent residency, leading to the request for passport at the end saying, no, I don't have it, but my identity was verified. And here's this true copy of the passport. And can you issue me a single journey travel document? I'm not going to say this is going to work, but I'm saying that there seems to be a structure by analogy to the overseas refugee pathway that this might be the venue to actually lead to permanent residency with a single journey travel document. And once you come to Canada, they would give you something like a passport, but it would be a single journey. It would be like a multiple entry travel document where you obviously could not go to your home country anymore, but you could still sort of function as if you have some kind of ability to travel outside of Canada as a permanent resident. I mean, I was going to close off this, but somebody joined. I mean, if they have a question, I want to first say the standard warnings, which is, I mean, this parts of this will be on social media, so you may or may not want to utter your question orally because then your voice might be on social media. And the alternative is you could pose your question in the chat. I mean, I'm going a little bit over time, but if somebody came in, then they could type their question in the chat. If they're thinking about their question, I can just pivot to the list of questions that I had here, which is, I hate when this happens because it's so unfortunate. This person says, I filed my application for permanent residency online, and I submitted the document the day of the deadline, and they refused the application because they said they did not receive it. So this is extremely frustrating because then you're dealing with the phenomenon of either emails or a portal. And if you submitted it the day of the deadline, the immigration department calculates this by a specific hour. I think it's universal or UTC time plus 6 hours. So it's not necessarily the end of the business day where you live. It might be a specific time zone. So you want to figure out in relation to that deadline, what time of the day did you file it? And then look up how the Canadian Immigration Department calculates the time, which I believe is 6 hours UTC. Figure out, did you file it? Did you get an AOR before that deadline? If you did, then you could ask for reconsideration, saying, according to the standards that you publish, I was technically on time. If you did not, then your case can be a little bit weaker, but you could still ask for reconsideration, saying that this is perhaps, hopefully, it's a non-substantive document, like a simple passport copy. It's not like a key document. Hopefully, it's something like a passport copy or a medical form, which doesn't really affect the complexity of the case to the officer to reopen it. On the other hand, if it's something more substantive or meaty, like a work reference letter, you could still make the argument for reconsideration, saying, this is something that doesn't take a lot of time for you to dispose of as an immigration officer, but it's a bit more risky. If you really want to protect your rights in this instance, then you could do what we suggest. you could hire a lawyer, like one of the ones at our office, to file a federal court case and simultaneously employ the reconsideration course of action. Sometimes the strength of that is that the immigration officer who's tasked with the refusal and may come across the reconsideration, they might also note that there is a federal court case filed, and that federal court case may trigger more work on the part of that Canadian immigration officer or that Canadian immigration officer's colleagues. And then if that federal court initial document shows that there is some merit to the case, this might buttress or strengthen the reconsideration request that was filed simultaneously with the federal court case. And then that might influence the officer to take more seriously the reconsideration request and then grant the reconsideration request. And in that case, then we would withdraw the federal court case, and then because it would become moot, the case would be continuing as if the deadline was not met. So those are the possibilities of what can be done in the case of application where a deadline was met and you're refused based on a technicality, which is so unfortunate. But in this case where you file something at the last minute, it's kind of not that diligent. So it's better to at least think about filing something 48 hours before the deadline, and then you would have your acknowledgement of receipt or your portal notification saying the document has been properly filed one clear day before the deadline imposed by the Canadian immigration authorities. So we're a little bit past time. So I'm at time. So I hope this was useful to anybody. And for those people who did not join, these questions that were posed will be posted on social media, anonymized. And my name is Mr. Max Chaudhary again, and this law firm is Chaudhary Law Office, www.chaudharylaw.com. And then feel free to reach out to us. Let me just type that into the chat, chaudharylaw.com, and to send a message to my assistant, book a consultation. So with that in mind, thanks for joining and enjoy the rest of your day. Thank you. Bye.